Assalamualaikum and Selamat Sejahtera. My name is Nurul Shuhada and today our group, which is Group 2, will be presenting infographics regarding case law in the English legal system. Now I will start with a brief history of case law. Before the Norman conquest, different areas of England were governed by different systems of law. These systems of law were often adapted from the various invaders who had settled there. For example, Dane law was practiced in the northern areas, Mercian law was used in the Midlands, and Wessex law was used in the south and west. Each law was based largely on local customs, hence it varied from place to place. The king had little control over the country as a whole, and there was no effective central government. When William the Conqueror gained the English throne in the year 1066, he established a strong central government and began to standardize the law. Representatives were sent out to the countryside to check local administration, and they were given the job of adjudicating in local disputes. When these representatives, also known as itinerant justices, returned to the Westminster, they discussed the various customs of different parts of the country. Through a process of sifting, they rejected unreasonable rules and accepted those that seemed rational to form a consistent body of rules. During this process, which went on for 2 centuries, the principle of stare decisis, which means let the decision stand, emerged. When a new problem of law came to be decided, a decision formed a rule to be followed in all similar cases, making the law more predictable. And by 1250, a common law that ruled the whole country had been produced. This law was applied consistently and is used to predict what the courts might decide in a particular case. It contained many of what now are basic points of English law, like the fact that murder is a crime. The principles behind this common law are still used today in creating case law, which is often known as common law. Next, on to judicial precedent. Case law comes from decision made by judges in the cases before them, and from the basic idea of stare decisis, a hierarchy of precedent grew up in line with the hierarchy of modern court system. In general, a judge must follow decisions made in courts which are higher up the hierarchy than their own, and this process was made easier by the establishment of a regular system of publication of reports of cases in the higher courts. The body of decisions made by the higher courts, which the lower ones must respect, is known as case law. Explanation of legal principles on which decision is made is known as ratio decidendi, which means the reason of deciding, and this part of judgment is known as binding precedent from case law. And when faced with a case on which there appears to be a relevant earlier decision, judges can follow when facts are sufficiently similar, precedents set by earlier cases followed, and law is applied in the same way to produce a decision. Other than that, judges can also distinguish. This is when facts of the case are significantly different from those of the earlier ones. Next is judges can overrule. Judges can overrule an earlier decision made in a lower court if they disagree with the lower court statement of the law. Outcome of the earlier decision remains the same but will not be followed. However, this is used sparingly because it weakens authority and respect of the lower courts. And lastly, judges can also reverse the decision. This is if the decision of a lower court is appealed to a higher one. The higher court may change it if they feel that the lower court has wrongly interpreted the law. Higher court is usually also overruling the lower court statement of the law. So that's all from me. On to the next presenter.
Assalamualaikum warahmatullahi wabarakatuh. My name is Nurul Shafika binti Amir, and today I would like to present to you about the hierarchy of court and how the judge decide cases. For the first one is hierarchy of the main civil court. The first court is country court. It deals with most of the cases in the civil court system and acts as the first instance court. The next one is high court. It mainly deals with civil cases and appeals from the lower country court. The next one is Court of Appeal Civil Division. Permission is necessary for an appeal in almost all cases, and in most cases, permission can be granted by the court whose decision is being appealed. For the next one is Supreme Court. It hears the majority of procedures from the Court of Appeal and sometimes to the High Court too. The last one is Court of Justice and European Union. The decisions here are binding on all English courts. Although it tends to follow its own previous decision, it is not bound to do so. For the next one is Hierarchy of the Criminal Courts. It starts with Magistrate Court. The cases here are heard either by approximately 2 or 3 lays or by a qualified district judge. The next one is Crown Court. It deals with served criminal cases such as murder, rape, or robbery. It also hears appeals and sentences from the cases from magistrate courts. The next one is Queen's Bench Division. The Superior Trial of the the Superior Trial Court for the province hearing trial in civils and criminal matter and appeals from decision from the provincial court. The next one is Court of Appeal Criminal Division, the second highest court below the Supreme Court and deals with appeal against sentence from the Crown Court. And the last one is Supreme Court. It is the highest appeal court on the civil and criminal cases and it hears appeal on arguable points of law and general public importance. For the next one is how do judges really decide cases? It is divided into four theories from four different persons. So for the first theory is from Dawkins, a seamless web of principle. Judges have no real district in making case law. He sees law as a seamless web of the principle and which supplies a right answer and only one to every possible problem. For the next theory is from critical theories, precedent as legitimation. These suggested that there is no such thing as legal reasoning in the sense of a logical neutral method of determining rules and result from the what has gone before. He stated that judicial decisions are based on a complex mixture of social, political, and personal factors and are simply justified by reference to previous cases. For the next theory is from Griffith, political choice. Judges make their decision based on what they see in public interest, but what their view is of this interest is colored by their background of their position in society. He suggested that the narrow social background of the highest judge combined with their position as part of the established authority leads them to believe that it is in the public interest and the established order should be maintained. In other words, that those who are in charge should stay in charge. And for the last one is from well-learned political choice, but why not? It argues he argues that this is not necessarily a bad thing. He contends that while it would be wrong for the judge to be biased towards one side of the case or to make the decision based on political factors in hope of a promotion. So that is all from me. I would like to pass to the next presenter.
Assalamualaikum warahmatullahi wabarakatuh. My name is Muhammad Atif and my Saifulikhmal, and I will explain to you about do judges make law. In the first place, historically, a great deal of our law is and always has been case law made by judicial decisions. For example, contract and tort law are still largely judgment and many of the most important developments. Secondly, the application of law, whether case law or statute, to a particular case is not usually an automatic matter. The terminology may be vague or ambiguous, new developments in social life have to be accommodated, and the procedure requires interpretation well as application. Thirdly, our judges have been left to define their own role and the role of the courts generally in the political system more or less as they please. They have, for example, given themselves the power to review decisions of any public body, even when Parliament has said those decisions are not to be reviewed. Lord Lowry suggested 5 factors were important. So first, where the solution to a dilemma was doubtful, judges should be wary of imposing their own answer. Second, judges should be cautious about addressing areas where Parliament had rejected opportunities of clearing up a known difficulty or had passed legislation without doing so. Third, areas of social policy over which there was dispute were least likely to be suitable for judicial lawmaking. Fourth, fundamental legal doctrines should be not lightly set aside. Five, judges should not change the law unless they can be sure that doing so is likely to achieve finality and certainty on the issue. So basically this guidance suggests that the judge should take quite a cautious approach to changing the law. Now I will explain to you about when should judges make law. Firstly, adapting to social change. In 1952, Lord Dennings gave a lecture called "The Need for a New Equity", arguing that the judges had become too timid about adapting the law to the changing conditions of society. Lord Scarman in 1982 stated that The court's function is to adjudicate according to principle, and if the results are socially unacceptable, Parliament can legislate to overrule them. Secondly, types of law. Lord Reid has suggested that the basic areas of common law are appropriate for judge-made law, but that the judge should respect the need for certainty in property and contract law, and that criminal law, except for the issues of mens rea, was best left to Parliament. Thirdly, consensus lawmaking. Lord Devlin has distinguished between activist lawmaking and dynamic lawmaking. He saw new ideas within society as going through a long process of acceptance. Fourthly, respecting parliamentary opinion. It is sometimes argued that judges should avoid making law in areas of public interest which Parliament is considering at the time. And lastly, protecting individual rights. In a 1992 lecture, the human rights lawyer Anthony Lester QC argued that while judges must have regard to precedent, they could still use their discretion within the system of precedents more effectively. So that's all from me. Now I will pass it to another presenter. Thank you.
Assalamualaikum warahmatullahi wabarakatuh. My name is Yasmin binti Rahim Helmee, and now I will be presenting advantages and disadvantages of case law, or other word binding precedent. Now, let's move on to advantages of binding precedent. The first one is certainty. Judicial precedent means that plaintiff can expect similar cases will be addressed similarly, rather than judges making their own conclusion. Next, the second one is detailed practical rules. Case law shows detailed application of the law to various circumstances and hence provides more information than written law. Then, the third one is free market and legal ideas. Case law evolve in line with market forces. It means that if a cases ratio is shown to be ineffective, it will be abandoned. But if it is found to be effective, it will be followed. As a result, the legislation can change in relation to demand. The last one is flexibility. Law needs to be flexible and adaptable in order to satisfy the requirements of a changing society. And case law also can do so far more swiftly than Parliament. Now, let's move on to disadvantages of binding precedent. The first one is complexity and volume. There are hundreds of thousands of cases that have been decided, resulting in thousands of volumes of legal reports, and more are being added all the time. Next, the second one is rigidity. Judges should follow a binding precedent even if they believe the law is wrong or improper. This can lead to faulty judicial decisions being upheld for a long period before they are brought before a court with the authority to overturn them. The third one is illogical distinctions. Because the facts of the case are significantly different, it can lead to judges find it difficult to distinguish between the facts of a previous case and the facts of the case before them. Then, the fourth one is unpredictable. If there are too many illogical distinctions, the benefits of certainty can be lost, and it may be impossible to figure out which precedents will be applied to a new case. The fifth one is dependence on chance. Case law evolves in response to the cases that are brought before it. Therefore, significant changes may not be established until someone has the financial means and drive to carry a case far enough through the appeal system to establish a new precedent. And lastly, disadvantages of binding precedent is lack of research. The judges are only presented with the facts of the case and legal arguments, and their role is to decide on the conclusion of that particular disagreement. They are technically unconcerned about the social and economic consequences of their actions, therefore they are unable to commission research or consult experts on these issues as Parliament can when revising the law. And that's all from us, Group 2.